Mr. Buckingham.
My lords, my lady, I was just about to turn to the Jordan 2. Perhaps before I go there, can I deal with the question about retrospective? The retrospective effects of overruling Buchanan, and in particular the problem that there will inevitably have been a large number of settlements based upon the assumption that Buchanan is right, understandably, which would be potentially unravelled and give rise to claims for payment under a mistake of law. We have in the supplementary bundle at page 158 the test claimants case in 2020, with which some of your lordships will be very familiar, and that addressed in part the running of time under section 32(1)(c) of the Limitation Act. And can I show you at 245, paragraph 193, discussing the purpose of postponement under section 32(1).
Supplementary bundle.
And it said, midway through that paragraph, that the purpose is achieved where the ingredients of the cause of action include his having made a mistake of law, if time runs for the point in time when he knows or could with reasonable diligence know that he made such a mistake with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice and collecting evidence. Now, there may be arguments about the precise point in time at which that state of mind could exist, but most obviously it would not exist unless and until Buchanan had been overruled, if that was the course that this court decided to adopt. So time on the face of it would start running this year, if that was the course your lordships adopted.
Well, if the issue became live, no doubt there'll be arguments run in favour of an earlier date, perhaps the date of a Court of Appeals decision in Sandeman, or arguments might be made that the academic commentators have been saying since the 1970s that Buchanan was wrong. So there'll be room for debate.
Yes, but indeed, and we would accept that. But we would submit that the most obvious date on the face of it, it would be the date when Buchanan ceased to be binding because it had been departed from. Until that date, it is binding authority which must be followed by any inferior court. It'd be perfectly natural for any settlement to be made on the basis of that decision, without speculating that it might subsequently be challenged.
I don't think this will be central to your argument, but the franked investment income case was designed to move away from the idea that the limitation period only started running when the Court of Final Appeal had made a ruling on the matter.
Yes.
But in any event, your point essentially is that there will be cases which have settled on the basis of Buchanan, which are within the limitation period, which could be unscrambled because of the mistake of law.
Yes, there would be that debate about when time starts to run, and there would be cases which have been settled, and that, however that debate was resolved, the payment could be unscrambled.
Yes.
That's sufficient. My lords and my lady, that does bring me to the Jordan 2 at page 1382.
Is this your eighth proposition and the sixth on which you're going to address us?
Yes, this is the eighth and ninth propositions as they appear in the written argument at page 151. But I haven't addressed you on all of them. And these are the last two on which I will address you.
I'm sorry, I missed the page reference for Jordan 2.
151 of the case.
I'm grateful. And the Jordan 2 is at 1382. And that is a decision, my lords and my lady, of the House of Lords in a strikingly similar case to the one before the court today. It concerned the interpretation of the Hague-Visby rules, and it was argued that long-standing House of Lords authority should be overruled, and that argument was made based largely on arguments relating to the travaux to that convention. And it's important in my respectful submission because it illustrates the approach to the practice statement in the mercantile context. And the background is that the Charter and the Bill of Lading in that case provided that responsibility for cargo handling was transferred from owners to shippers, charterers, and consignees. And the question was whether that was invalid under Article 3, Rule 2 of the Hague-Visby rules, and whether the House should depart from the previous authority of the House of Lords in Renton, which had decided that the transfer of responsibility was not invalid. And one picks that up at 1387, letter H. And it said that the ratio decidendi of the house in Renton is now common ground. The leading speech was given by Lord Steyne, with whom all other law lords agreed. And at 1388 at the bottom, paragraph 15, one can pick up that it had been 50 years since Renton was decided, and his lordship observed that an enormous number of transactions had probably taken place on the assumption that the case represented the law, and that there are likely to be many more open transactions not yet finalised by judgment, which were concluded in reliance on the rule. And then paragraph 16, he cites a dictum of Lord Mansfield, Vallejo and Wheeler, that in all mercantile transactions the great object should be certainty, and therefore it is of more consequence that a rule should be certain than whether the rule is established one way or the other, because speculators in trade then know what ground to go upon. And the respondents respectfully adopt that dictum and submit that it applies with particular force and relevance in this case. And then in the next, the bottom of paragraph 16, letter E, his lordship refers to Lord Bingham in the Homburg case, and says that is, of course, not to say the House might not be persuaded under the practice statement to depart from an earlier decision, where that decision has been demonstrated to work unsatisfactorily in the marketplace and to produce manifestly unjust results. And in this case, in that case, it wasn't satisfied. And in my submission, that is the applicable test that the court should apply, given the mercantile context in which this case arises. And Lords, just while we're in this judgment, at 1391, paragraph 20, Lord Steyne addresses the use of the travaux. And I'll come on to this in a little while, but it makes sense to refer to it while we have it open. And he refers to Fothergill and Monarch Airlines, in which the travaux was discussed and admitted for the first time, and says it's equally well settled that the travaux can only assist if Lord Wilberforce put it in, as Lord Wilberforce put it in the Fothergill case, if they clearly and indisputably point to a definite legislative intention. The general thrust of the travaux was put forward. The judge recognised this, but he also pointed out that nowhere in the travaux is there any statement that Article 3, Rule 2 prevents an owner or merchant from reallocating responsibility. Now, Lords, my lady, that is important in our submission, because that is being advanced as the test for reference to the travaux generally, in any circumstances. I picked up from my learned friend's submissions that he sought to draw a distinction between using the travaux to confirm an interpretation and to settle a dispute between rival interpretations. And he suggested that one only needs a bullseye for the latter purpose. And in my submission, that is wrong, and it's contrary to authority. And I'll come back to show you Fothergill and the other authorities. But it's certainly contrary to what is said at paragraph 20 by Lord Steyne. And then at page 1393, paragraph 27, Lord Steyne discusses whether a departure from the Renton case is justified in this case. And he notes that an opportunity arose in 1968 to improve the operation of the Hague Rules. An international conference took the view that only limited changes were necessary, and had the decision in Renton worked unsatisfactorily in practice, one would have expected that to have emerged at the conference which led to the protocol later signed at Brussels. And a little later at E, if in the United Kingdom there had been dissatisfaction with the effect of Renton, one would have expected British cargo interests to have raised it when Parliament considered the bill which was to become the Carriage of Goods by Sea Act 1971, which introduced the changes to the Hague Rules. If invited to do so, Parliament could have considered whether Renton should be reversed. The matter was not raised at all. Instead, Article 3 Rule 2 is reenacted in unaltered form. And one can obviously draw parallels with this case. And I shall come on to that in a moment.
Yes, the last sentence of that paragraph, however, points slightly in the other direction. No academic writers have argued that the Renton case should be reversed. That's not the situation here.
Yes, that is, the two differences are that here one has the judgment of the Court of Appeal in Sandeman, and one has academic writings in this jurisdiction and in Europe. I might just add on that we have not ourselves conducted a search for academic writings throughout the CMR world. It may well be there are discussions that are in support of Buchanan. We don't know. We haven't undertaken that exercise. So one can't assume that there is no.
Yes, but your big point from these paragraphs is that there is no indication that the system is working unsatisfactorily as far as the insurers and the carriers are concerned.
Correct. Yes. Indeed, on the contrary, all the indications that we have in this case are that it works perfectly satisfactorily. As I said, there was an international conference in relation to the CMR shortly after Buchanan was decided in 1978. That led to some changes to Article 23. So Article 23 was under the microscope, and that would have been an obvious opportunity. If anyone had had any misgivings about the decision in Buchanan, that would have been the obvious opportunity to raise them, but they weren't. And indeed, Article 23 was amended, but Article 23.4 was not. And the changes were then implemented in this country in the 1979 Carriage of Goods by Air and Road Act, and again, without any disquiet being raised as far as we can tell. And there's a related point in the CMR Convention itself, in Article 49, there is a specific mechanism, which I suspect is common to many international trade conventions, that allows a party, if there are problems with the way in which it's operating, to call for a conference to be held to review the convention. And if 25% of member states agree that that should happen, then a conference will be promulgated and discussions can take place. And as far as we know, there's never been any move to use that mechanism under the CMR. Now, as we have set out in some detail in our written case, that there are grounds on which this court and the House of Lords previously have been prepared to depart from previous decisions. But in the present case, we say none of them are fulfilled. There is no manifest injustice. I was proposing to say that, and none is suggested, but in Mr. Kimball's submissions, for the first time, it was suggested that there was something unjust about a carrier who has lost duty goods being required to meet the charge for excise duty. But that's a recent innovation to the case. It's still not suggested that there's any change in circumstances, as I understand it. And I don't think it's suggested that any difficulties arise in practice, and we certainly say that they don't. And the joint statement of the parties, which I may come to, demonstrate that as far as these parties are concerned, they're not aware of any difficulties arising. On the other side of the equation, there are very strong countervailing considerations to departing from Buchanan. First and foremost, we say, this is a mercantile case where certainty is the paramount consideration. Secondly, the issue at hand is a question of interpretation. There are two rival views, and the matter has been decided. Thirdly, we submit that this is a case where Lord Mansfield's dictum that was cited at paragraph 16 in the Jordan 2 is of particular relevance and importance. And as for the basis on which we understand the appellants to seek to justify this court departing from Buchanan, it seems to us they're set out in paragraph 12 at page 63 of the main bundle in their written case. And there they say two things. They say that Buchanan perpetuates uncertainty because it introduces national law concepts, the assessment of damages, which subsequent courts have struggled to apply, but the only case that is referred to is Sandeman itself. And secondly, they say that Buchanan undermines the economic rationale of the CMR Convention. We say quite firmly that both of those propositions are incorrect. And I will turn now to my next topic, which is to look at the economic rationale and the legislative aims of the CMR as they're put forward by the appellants and the Travaux. And in order to do that, it is necessary to begin by looking at what is suggested on the appellants, what aims they put forward on behalf of the CMR. And one has to trawl through their written case to pick them all up. The first is at page 69, paragraph 37. And they quote from the preamble to the CMR, and it's a quote that Mr. Kimball spoke to in his submission this morning. And they say in paragraph 37 that this was the primary objective of the drafters of the CMR. Now we submit that's a mischaracterization because it's not described as the primary objective. It is in fact the only objective that one will find in the CMR Convention itself. None others are expressed. Nor is it accurate or relevant to describe it as the objective of the drafters. In my submission, this is quite an important point because the way in which the Travaux is presented and addressed in the appellant's written case is on the basis that it shows what the intention of the people drafting the various texts was at various times. But if legislative intention is to be divined, it must be of the contracting parties themselves or their delegates. It is no good looking at the workings of a subcommittee and then speculating or inferring what a particular delegate may or may not have thought about that. Also in paragraph 37 of their written case, they refer to another alleged objective, again not of the parties but of the drafters, and they refer to a preliminary study at footnote 29. And then if we come to paragraph 38 of their written case, there is reference to what I described as the three principal aims of the liability provisions in Chapter 4, Articles 17 to 23 of the CMR. For the first two of these, references are given in footnotes 30 to 31, to documents which are relied upon as being Travaux documents. But for the last, no supporting reference is given, and it appears that it's the appellant's own interpretation. And then one has to go to page 94, paragraph 112, and a total of 7 additional propositions are set out on page 94 to 95 and are described as key points. And in footnotes 133 to 144, a number of further documents are referred to, which are again relied upon as being part of the Travaux. And as we understand it, these various contentions about the underlying policy aims of the CMR are the key planks in the appellant's argument that the broad interpretation of Article 23.4 of Buchanan was wrong. Now, before turning to the Travaux itself, we have addressed in our written case the test, as we see it, in relation to which Travaux can or cannot be used for the purposes of interpretation.
I wonder if you can help us with the definition of Travaux. In previous cases like Fothergill and Monarch Airlines or Morris and KLM, what the court has looked at has been the official record of the negotiation of the treaty. So typically the minutes of the relevant conference. In this case, we're being asked to look at documents at a level below that, sort of working papers which might find their way into the subsequent discussion between the delegates of the contracting parties, or might not, for all we know, but there it is. Are you able to point us to anywhere where we find a definition of what's meant by Travaux?
Well, Lord, I was going to take you to Fothergill, which I suspect is a good starting point. But in our submission, the Travaux is as your Lordship describes it, because its relevance and its purpose is to shed light on what the parties to the convention intended. And whereas there may well be lots of documentation produced by, if I can put it in this way, the backroom staff, that doesn't necessarily shed any light on what was in the minds of the drafters. Or if it does shed light, it's not clear what that light is. What one needs is a bullseye, as described by Lord Steyne in the Janus NK. But perhaps if I start with Fothergill, which is at page 1070.
The irony in Fothergill is that Lord Wilberforce, of course, had been the delegate. He knew better than anybody what had been going on in the negotiations.
1070.
up at 1070, D, there is little firm authority in English law supporting the use of travaux. And then F, when dealing with an international treaty or convention, there is no doubt that international courts do in general make use of travaux préparatoire as an aid to interpretation. And then over the 2 pages at 1072.
It may be helpful just to put this in context if,
Yes.
if we go back to 1049, where you see what the argument was. Council were asking the House to look at travaux, it's about a third of the way down the page, look at travaux préparatoire in the form of the minutes of meetings at which the Hague Protocol to the 1929 Warsaw Convention was negotiated. So the travaux there would be of an uncontentious nature. I mean, it's the minutes of the negotiations.
Well, yes, indeed.
Yes, so I thought it helpful to just to spot that point, but you had us further on.
So that was certainly is the context in which the travaux is being debated, and that is the material which is in the minds of the court.
But I mean, on page 1070, I mean, Lord Wilberforce is referring effectively to use of the travaux préparatoires as made use of as a matter of international practice in the interpretation of treaties. So I'm not sure that it would be a specifically English definition that one would be looking to.
No, it certainly wouldn't be.
Yes, my lords, and then...
I mean, it's the meaning that it has in Article 32 of the Convention that would be relevant.
Yes, I was going to take your lordship to do that. At 1072, still in the judgment, the speech of Lord Wilberforce, just to complete this point, at B, if one accepts that this reflects a recognition of the use of travaux in the interpretation should be cautious, I think it would be proper for us in the same interest to recognise there may be cases where such travaux can profitably be used. So the context is a discussion about the use of travaux in any circumstances. There's not a particular use confirming or choosing between two different interpretations. It is directed at the use of travaux in any circumstances. And Lord Wilberforce continues that these cases should be rare and only where two conditions are fulfilled. First, that the material involved is public and accessible, and secondly, that the travaux clearly and indisputably point to a definite legislative intention. So even if one is confirming what one, for other reasons, believes the correct interpretation to be, that is the test that must be applied before the travaux can be deployed. And your lordship referred to the Vienna Convention, which we have at page 372 of the main bundle, Article 31. 1, the treaty should be interpreted in good faith in accordance with the ordinary meaning to be given to the terms and in light of its object and purpose. 2, the context shall comprise, in addition to the text, any agreement relating to the treaty, and then any instrument which is made by one or more parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument related to the treaty. And there should be taken into account subsequent agreements and subsequent practice. And then 32, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion. So it may be that that is capable of a slightly wider meaning. However, if one is to actually gain any insights from what the travaux is telling you, then necessarily it has to reflect the intention of the parties to the treaty, and not merely the individuals tasked with drafting the text and doing the backroom work, as it were.
This was entered into after CMR, wasn't it?
Well, yes, it was. Yes, it was.
And you say it reflects international practice for that time.
Indeed, but we will accept that. My Lords, then there is the judgment of the Court of Appeal in the Lady M, which usefully summarises the principles and refers to the judgments at 1533 in the bundle. And one picks it up at 1545 under the heading Glencore's argument on the travaux préparatoire. Two relevant questions in relation to the travaux: what is the test for recourse and how do they assist? And they quote the well-known judgment of Lord Steyne, the Janus NK, which cites Fothergill, and then says towards the bottom of the page, I would be quite prepared in an appropriate case involving truly feasible alternative interpretations to allow the evidence contained in the travaux to be determinative on the question of construction. But that is only possible where the court is satisfied that the travaux exclusively point to a definite legal intention. And I think that perhaps is the basis for learned friends' attempt to drive a distinction between the need for a bullseye in that situation when one is using it to determine which of two interpretations is correct, but the suggestion that it's not necessary to have a bullseye where you're merely confirming the convention. But in my submission, that is not what Lord Steyne had in mind, and see his reliance upon Fothergill in that quote. At the top of the second column, see also to similar effect Lord Steyne's remarks in the Jordan 2, which I've shown the court. And then we have Fothergill itself in paragraph 89, and the extract I've already shown you. And then at paragraph 90, another consideration, a potential objection, which may or may not apply in any particular case, that it's possible that parties to an international convention may choose, or at least acquiesce in imprecise language. So, Lords, as a result of those authorities in our submission, it follows that when you consider the travaux, in looking at each document which is put forward by the appellants, you should have in mind the nature of that document. And there are two particular considerations to have in mind, we respectfully submit. The first is that if the document contains or reflects statements of shared intention of the parties, it is not enough that it reflects backroom workings or opinions or discussions of the people drafting the convention. Material of that nature is not capable of fulfilling the test. And secondly, what passage is relied upon? Because the travaux is quite liberally spread through the appellant's written case, and we have spent some considerable time trying to identify the passages suggested to support the particular propositions which are contained in the written case at different places, without much success. So before one can say this piece of the travaux supports a proposition, one must obviously have in mind a particular passage or aspect of the document. And the suspicion is that really what the appellants had in mind was the general thrust, which of course is insufficient. And one can give an example of this problem, and it relates to the appellant's written case at paragraph 40, 40(2) on page 70. And they say at the end of that paragraph that the similar language of Article 6.1.1 and Article 23.4 is not a coincidence, and this is something Mr. Kimball addressed you on this morning. We do not accept there is any significant similarity of language. We would say that the differences are more important than the similarities. But my purpose in looking at it now is to see the document deployed in support of footnote 35, the trans WP 928 document, which is to be found at page 3961. And this is put forward for the proposition that it's no coincidence that there is a similarity of language. And one sees immediately that the nature of the document at 3961, it's a communication from the government of Switzerland. So it's effectively a submission from one of the state parties, or at this stage, negotiating parties, to the Inland Transport Subcommittee on Road Transport, and indeed the ad hoc working party thereof, putting forward the Swiss view. And I think you were taken specifically this morning to page 3964, and it was suggested that that confirms the proposition for which it is cited in the written case. But in our submission, it does nothing of the sort. This is simply the opinion of the Swiss government put forward to the committee. And my lords and my lady, in their written case, that there is no reference by the appellants to the high threshold required for the admission of travaux, and they have not in that document purported to identify any bullseye document. And in our submission, there are none. There is nothing in the travaux that sheds any light on the intention behind Article 23.4, or what was intended by charges, or indeed anything about insurance or insurance arrangements or double insurance, as is suggested. But there is simply nothing that meets the test set out in the authorities. And therefore, this is another one of those cases where the travaux leads nowhere. And therefore, the key planks of the appellant's case, which we see they built up in their written case, must fall away. The basis on which they suggest Buchanan is wrong is itself misconceived, in my respectful submission. And before turning away from the travaux, this is perhaps just a convenient point to mention the SIM Convention and the changes that were promulgated to the equivalent provision in SIM, about which you heard a little this morning. And the appellants placed some reliance upon that in their written case at page 67. In paragraphs 28 to 31. And in 31, they conclude with two propositions. They say that their interpretation of 23.4 would lead to a harmony between CMR and CIM, and secondly, that this would be in accordance with the intentions of the drafters of the CMR as shown in section G. Now, section G is a reference to the Travaux. So our position in relation to that is that the second proposition necessarily fails. But the first proposition is also incorrect. It is not right that the appellant's narrow interpretation of Article 23.4 would lead to harmony between the CMR and the CIM. Lord, and I can show that by reference to two documents. The first is a bulletin of the Central Office for International Rail Traffic, or COTIF, at Supplementary Bundle 497. And this is a document which sets out, prior to the changes being promulgated, what the perceived problems are. And one sees in the right-hand column, the Central Office has given its view on the application and interpretation of Article 40 SIM, and it sets out what the provision at that time was. And the Central Office has pointed out that excise taxes and excise duties are not to be reimbursed for the following reasons, and they give their reasons. And the context is that different jurisdictions took different views, much as they have in the context of the CMR. And then one sees that at the bottom of the right-hand column, the question of the sums to be reimbursed in the event of total or partial loss was also examined by the Audit Committee, otherwise known, I think, as the Revision Committee, at its sixth session in connection with the wording of Article 29.3. And the question was whether the term other amounts paid at the time of carriage, 498, that doesn't seem to continue, but at 498 one sees that the Audit Committee sought to introduce some amendments to this article in order to make clear that only duties and excise duties already paid are to be reimbursed, and that the context of carriage was a necessary prerequisite. And then at the time of the 16th meeting, the French requested that excise duties be expressly excluded from the concept, and one sees that the text that was then developed by the Revision Committee to cater for that. That text was considered to go beyond an editorial amendment, and the Central Office reformulated it, and we see at the bottom of the right-hand column the reformulation preferred by the Central Office. So that there was a process of discussion and negotiation involving at least the French delegation and the OTIF body. And then there's a later note at 2708. The main one.
Those two proposed texts seem to me to mean the opposite to each other.
Yes.
Well, it is not clear. I think the intention behind the second text at the bottom is that if you paid customs duties and excise duties already, then they can be recovered. Whereas
the concept of reimbursing, I thought that in any event you could only recover from the carrier charges that you've actually paid. So if the fact that the goods get lost in Poland means that you don't actually end up paying customs duties to move them into Germany and then to France and then into the UK, you can't presumably recover those unpaid customs duties.
Indeed. But what this illustrates, we say, is that there is a process of discussion and negotiation going on, and the particular motivations behind it, and the explanation for the different texts is actually quite obscure. It's not clear what's going on or why. And one picks that up as well from 2708.
And the impression one gets just from the text you've shown us is that the drafting committee were in fact concerned that there would be the sort of issue that has been debated this afternoon, that you'd be unscrambling transactions where people had in fact paid the excise duties under the old version of SIM, and they were concerned that would be unfair if they adopted the new text, which would unravel those transactions.
Indeed, and that was the product of a similar sort of disharmony.
Yes, absolutely. I mean, if anything, it tends to show that there was something of a practice of the excise charges being paid under the 1933 SIM arrangement.
Yes, indeed.
But your point is, what it doesn't say is, oh, well, of course everybody knows that excise duties aren't included, but we'll just put this in, not to change things, but to make it absolutely clear.
That is indeed what they were doing, seeking clarity in circumstances where there was a lack of clarity and different courts had taken different views. We don't accept there's any connection between the interpretation of SIM and CMR. I simply refer to this to illustrate how one goes about addressing that sort of issue. What is the appropriate way of dealing with concerns about the meaning of an international convention that is interpreted in different ways in different jurisdictions? And what the party to SIM did was to have a process of discussion and negotiation, which resulted in what one sees at page 2708. And this describes some of the background, that there were differences of opinion in different jurisdictions.
We've picked it up at, we started this on page 497.
Well, I do apologise. I've moved on to another document.
No, at all. I'm just remarking that if you go further back, what we're actually looking at is a decision of the French courts holding the insurers liable in respect of claims in respect of excise duty, amongst other things. I think at the end of the decision on page 496, the court rules that the excise duty will be due from the date on which it's requested by the tax administration. It's to do with thefts of cigarettes from a train in France, by the look of things.
Well, Lord, indeed, and the commentary I was showing the court follows on from that report of the case, relevantly, given that view taken by the French court.
Yes, because it's a judgment of the commercial court in Paris, and the claim was for reimbursement of duties and taxes that could be levied by the Dutch and French administrations, including the excise duty associated with the transfer of cigarettes into circulation. In other words, the same type of claim as we're dealing with.
Indeed, Indeed, that is an example of which there are many, of the approach taken by different courts. And I'll come on to that very briefly to look at different approaches in different jurisdictions. But the point of the document at 2708 was simply to show where the SIM changes ended up.
Yeah.
And one sees that at page 2709, where it's described that the question of compensation and refunding was the subject of discussions during the work on revising COTIF in 95 to 99, both in the revision committee and then in the General Assembly, in relation to a debate on a new wording. Without the intention of making an amendment, it proved necessary to have another discussion on the principle when the Fifth Assembly took a decision. It was eventually concluded that the excise duties referred to, as opposed to duties already paid, must continue, that's their commentary, to be excluded from the carrier's obligation to refund. And then one sees that the wording which is finally passed by the parties in the General Assembly, which again is different to the wording which has been proposed at different times by different committees, as we saw in the previous document.
So do you interpret the statement in that paragraph as opposed to duties already paid as indicating that this is perhaps not wholly prospective, but not wishing to reopen transactions where the carrier has in fact paid compensation to the consignor? I just wondered, it was the point I think that Lord Sales raised about what was meant by this exclusion of duties already paid.
Lord, I must admit, I hadn't interpreted it in that way. The way in which I had looked at this was that you have very much a hybrid solution. The debate before the court is whether to adopt a narrow view or a broad interpretation of what the phrase "other charges in respect of carriage" means. That is not the approach that's been taken here, that they didn't adopt a narrow or wide interpretation. They specifically carved out excise duties. And we would submit that the wording chosen is susceptible of an otherwise broad interpretation, subject only to excise duties. So it's very much a hybrid solution to the problem, which is a sort of solution one can achieve through international discussion, but of course a national court deciding between two cases is not able to.
I mean, just on the fragmentation point, if one goes back to the start of this document at page 2708, it sets the context for it, which essentially is fragmentation. There have been different decisions by courts under the SIM
Yes.
as to whether excise duty is brought within the scope of compensation or not.
My Lord, yes, it's exactly the same problem that we have with the CMR. Indeed. So, my Lord, that is all I was proposing to say about the Travaux and SIM, and you have my overall submission that the Travaux takes you nowhere in this course, in this case. And I turn to consider Buchanan, Sandeman, and the English case law. And we have addressed the reasoning of the Court of Appeal and the House of Lords in Buchanan in our written case. So the court has that. In the Court of Appeal, Lord Justice Roskill and Lord Justice Lawton, and in the House of Lords, Lord Wilberforce, Viscount Dilhorn and Lord Salmon, all considered that there are two possible interpretations of Article 23.4. They all considered that the words were capable of bearing the meaning under the broad interpretation, and further decided that was the correct interpretation. The respondents submit that the broad interpretation is at the least a plainly legitimate and tenable interpretation of the words, as demonstrated at least by the fact that 5 out of the 8 judges that considered the phrase favoured that interpretation. And we also go further and say it's not simply tenable, but it's also correct, essentially for the reasons that were given in the judgments and speeches. And in considering whether the broad interpretation is at least tenable, the court should also have in mind that Buchanan has been expressly followed by the Supreme Court of Denmark, the Supreme Court of the Czech Republic, and the Supreme Court of Lithuania. And it's common ground that that's the position taken in those jurisdictions. The Court of Appeal of Turin in Italy has also adopted the broad interpretation, but without reference to Buchanan. It's come to its own view. I'll take the court to look at that in a second. There's a dispute about Belgium. We say the Belgian Supreme Court has adopted the broad interpretation as well. So for all of those reasons, it's a legitimate and tenable interpretation. And although it's right that there has been criticism from United Kingdom commentators over the years, it's actually quite muted criticism. And I'll show the court what is relied upon by the appellants, in fact, and it's in their written case. Firstly, at page 78 of the bundle, paragraph 67, and this is the initial reception of this decision of the House of Lords, said to be negative, and the appellants refer to the views of Mr. Hardingham, who is one of the commentators that has made his views known. But one sees over the page at 79, overall his conclusion is that for the reasons he's given, the minority's view seems preferable to that of the majority. So that this is not a condemnation of the decision, it's simply the expression of a preference. And then at paragraph 71 on page 80, the views of Professor Clark are set out, and we would submit that the description given by the appellants in the introduction to that passage, that Professor Clark has expressed a firm preference for the narrow interpretation, is a fair summary. That's his preference, but nowhere is it suggested that he has dismissed the broad interpretation favoured by Buchanan as being untenable. Now, my lords, my lady, what we have attempted to do in our written case is to address all of the criticisms raised by the Court of Appeal in Sandeman and commentators and the appellants at any time. And you have that in our written case. What I was proposing to do orally was to take the particular criticisms that the Court of Appeal had in Sandeman and address them and explain why we say they are not convincing criticisms.
So on the commentators, although you say you haven't done a complete trawl, the only commentator you found supporting the wider interpretation is Lowe, is it?
Yes. Yes, that's right. We haven't conducted a trawl at all of European commentary. the domestic commentary it's a fairly niche subject, the CMR. So we have the views of Professor Clark and Adrian Hardingham, and with Mr. Messent. Those are the commentators, really. So there isn't much more beyond that. So we have the Court of Appeal in Sandeman at page 1329 of the main bundle. And picking it up first, just to show the court how the argument proceeded, because it is quite important to understand that Article 23.4 wasn't actually the main point of dispute in this case. It was an alternative basis for a claim, and perhaps understandably, it doesn't seem to have been the subject of much time in argument. So one picks it up at 1333 at the bottom. Mr. Nolan represented the claimants, and then over the page at 1334, at G and H, he sets out the alternative argument that the loss is in any event recoverable under paragraph 4 of Article 23 of the CMR. And essentially he says he relies upon Buchanan, and that's really all he says about it. And then in 1335, we have the argument for the second defendants, Mr. Meeson, QC, and that's at the bottom of the page, letter H. His submission is that other charges in 23.4 cannot include any charge, however remote. He says that Buchanan's been criticised, and it's his submission that it should be restricted to its own facts. And he makes that submission on the basis of the article by Professor Clark and by Hill and Messent and Palmer and Bellman, which I think my learned friend has shown you or referred to. And he makes a submission that Buchanan is distinguishable. And then at 1337, B to D, Mr. Coburn, for the third defendants, adopts the second defendant's submissions. And then at letter D, he sets out that the basis he suggests for distinguishing the two cases, and says Buchanan is distinguishable. And then 1338, at letter H, Mr. Nolan in reply, and his submission is you are bound by Buchanan and it's indistinguishable. So it seems that there wasn't really much argument about whether Buchanan was correct. And of course that's understandable because the Court of Appeal was bound by it. The argument really seems to have focused on whether it was distinguishable on satisfactory grounds.
I'm not be sure I understand the facts. The consignment was a consignment of pieces of paper which were tax seals.
Yes.
And the seals, as pieces of paper, had no inherent value, but when they were attached to a bottle, they signified that excise duty had been paid.
Yes, indeed.
Yeah.
So the loss of the seals attracted a charge to excise duty because they represented the duty that had been paid.
I mean, there were evidence of the payment of they functioned as evidence of the payment of excise duty.
Yes, yes.
The assumption is that they're going to be attached to bottles on which excise duty has not actually been paid, and therefore the revenue will lose that excise.
Yes, exactly. And a guarantee had been given in relation to the excise duty that would be paid, and it was that guarantee that was called upon to enforce the excise duty charge that was made.
Yeah.
So, my Lord, as we analysed the judgment of the Court of Appeal, there were 4 particular criticisms made. The first is at 1345G.
The loss of the seals triggered the consignor's liability under a guarantee. That's basically what it came to.
Yes.
It's the amount of that liability that is in issue in the proceedings.
Not so much the amounts, but where the...
Well, I mean,
yes.
whether that can be recovered from the carrier is the issue.
So one picks up the first criticism at 1345G. In the absence of authority, we would have answered this question in the negative, and that's is excise duty within the phrase other charges incurred in respect to the carriage? We would have answered that question in the negative. It seems to us that one object of the Convention is to make a clear apportionment of risk arising in the course of international carriage by road, so as to facilitate insurance and avoid double insurance.
Are they right in focusing on excise duty? Had the Spanish authorities actually levied excise duty, or were they enforcing a guarantee for the payment of an amount which was equivalent to the excise duty evidenced by the seals?
Well, there was a charge to excise duty which was enforced by means of the guarantee.
So the seals and the guarantee are a mechanism by which they impose a liability to excise duty for the lost seals.
Yes. So although the manner in which the excise duty was charged was different as compared to Buchanan, it's not a different type of liability, we would say. It's just a different means by which it was felt. And of course, the giving of a guarantee in relation to excise duty is common. It's the normal manner in which excise suspension arrangements are supported, that a party to the transit will give a guarantee in relation to the suspended excise.
So in this case, Sandeman's would have taken these seals, put them on their bottles, then presumably imported those bottles into Spain.
Yes, I think that's right.
And at that point would have paid the excise duty. But in this particular case, given that the seals were stolen, the guarantee was called up and they had to pay the duty that would have been due had the seals been put on their bottles.
Yes, I think that's right. That's exactly right. So the criticism that's made relates to the perceived intention of the CMR Convention, as the Court of Appeal sees it, to facilitate insurance and avoid double insurance. The first point the respondents would make is it's not clear on what basis the Court of Appeal came to the conclusion that these were aims of the CMR Convention. Now, they didn't have the benefit of any travaux, so it wasn't on the basis of that. It may simply have been their interpretation of the effect of the articles 23, 3, 6, 24 and 26 that they refer to in paragraph 35.
So for state insurance, that reflects predictable amounts of liability. Yeah.
Well, it seems that the perceived menace was more double insurance, which we understand to be the situation where each side, cargo interest and carrier, are insuring against the same exposure.
I see that, but predictability of your liability will facilitate insurance, and if it's low, keep it cheaper.
If predictability in any real sense is achievable, yes.
But what do you say we need to do about Sandeman if we are with you in upholding Buchanan or declining to depart from Buchanan? Where does that leave Sandeman, given that Mr. Kimball's case is that because of Sandeman, there's this supposed distinction on the facts between Sandeman and Buchanan, which nobody can really tell what side they happen to fall on, because they seem to be basing the distinction on a mechanism rather than a liability for excise duty. For all we know, there may be other taxes which also operate on this guarantee, or maybe some people give a guarantee in order not to have to pay excise duty up front. I don't know how it works. We haven't got any information about how this excise duty on lost bottles or lost seals is enforced and collected by HMRC in the usual course. So what is your case about Sandeman?
Well, we would respectfully invite the court to do two things. The first is to disapprove the comments in paragraph 38 at 1347. And this is the passage where the Court of Appeal says that for their part, we do not consider that the decision should be applied any more widely by the courts of this country than respect for the doctrine of precedent requires. And that, the appellants suggest, I think, has been interpreted as something of a clarion call to distinguish Buchanan on insufficient grounds. And that, potentially, if that's right, if that's how it's interpreted, has the potential to cause uncertainty. So that comment can be disapproved, and in my submission should be. That's the first point. The second is that the ground of distinction that the Court of Appeal settled on between Buchanan and Sandeman is an unsatisfactory one. And to that extent, we would invite the court to overrule Sandeman. For the large part, Sandeman was about different issues. It was about bailment and non-CMR points.
When you read the early paragraphs of the Sandeman judgment, it's clear that what was an issue was not excise duty, but the payment under a guarantee of a sum equivalent in amount to excise duty. Now, it's easier to describe excise duty as a charge in the language of Article 23(4) than to describe a liability under a guarantee to a third party, a contractual counterparty, as a charge. So there may be a ground of distinction which isn't the one the Court of Appeal drew, but is nonetheless a possible ground.
Lord, if the court takes the view that there is a satisfactory ground on which Sandeman can be distinguished, then that does not impel certainty.
We don't know anything about, for example, the jurisprudence of other courts, including the Spanish courts, as to how the CMR applies to this type of situation, the Sandeman type of situation. Do we?
No, Lord, I don't think we do. No.
Why do the tax authorities need to impose a guarantee, require a guarantee? Surely they can just impose a tax on the person.
Well, I can show the court how in modern times the procedure works, because we have the council directive which governs suspensions of excise duty for transport at page 710 in the bundle. And it's quite a short point. But one sees at page 7 1.8 that excise duty becomes chargeable when there's a release for consumption, which includes an irregular departure from duty suspension arrangements. And at the bottom of 718, Article 8, the person liable to pay the excise duty that's become chargeable shall be, in little 1, the warehouse keeper or the consignee, but more importantly, in little 2, in the case of an irregularity during a movement of excise goods under a duty suspension arrangement, the warehouse keeper, the registered consignor, or any other person who guaranteed the payment in accordance with Article 18. And if one looks at Article 18 on page 723, the directive requires that the competent authorities of the member state require that the risks inherent in the movement under suspension of excise duty be covered by a guarantee provided by either the warehouse keeper or the consignor, or then in 2, by derogation, other parties, including the consignee, can be asked to give the guarantee. So as a condition of using the duty suspension arrangement, a guarantee has to be given by a party involved in the carriage.
A guarantee from a bank or?
No, a guarantee from the consignor, the carrier, or the consignee, or the warehouse.
Provide a guarantee to pay, to undertake a liability that you're not already subject to.
Yeah, I think that may be the situation. When one looks at the opening paragraph setting out the facts, it explains, as you would expect, that excise duty is payable on the spirits, and under the Spanish law, it's payable on importation of, say, whiskey into Spain, or release of the whiskey from bond in Spain onto the Spanish market. But this case was to do with the transportation of the paper seals from Madrid to Paisley, and they got as far as Bradford, but got lost somewhere between Bradford and Paisley. So there wouldn't be a chargeable event for the levying of the excise duty in those circumstances, it seems. Because no whiskey can be shown to have been released from bond or
No.
Otherwise onto the Spanish market.
No, it's not the identical situation to one where the dutiable goods themselves are lost. I agree.
As you would have thought, from the carrier's point of view, the foreseeability of excise duty, if you're carrying cigarettes or whiskey, would be quite easy to ascertain. But the foreseeability of for the carrier of the carriage of these seals might be completely different.
Yeah.
Well, it may or may not be. I can see why it might be, depending on the scenario.
In terms of Article 23.4, you're talking in English about charges in respect of the carriage, aren't you?
Yes.
In French, it's frais à l'occasion du transport. And one might well say, I'd have thought that a contractual arrangement between the consignor and the Spanish government is something quite, it's too remote. Well, it's certainly a remoteness test. It's too remote from the contract of carriage to be regarded as falling within those terms, unless of course the consignor has been put on notice of it under, say, Article 26.
Well, it may be that there are, as I say, that there are grounds on which a more satisfactory distinction can be developed, but certainly our primary submission would be that there isn't, and the attempt to distinguish on certainly on the grounds that the Court of Appeal put forward is not convincing.
It's right, isn't it, that the Court of Appeal addressed the question of remoteness and said that it didn't apply
Yes.
under the convention.
That was the view they rather tentatively expressed, I think.
Yes. Well, remoteness, certainly as an English legal concept, obviously the English legal concept doesn't apply, and it may not be an apt way of an apt term, but I was trying to find a way of explaining why the language of Article 23.4 might not apply to this, and it has to do with the connection between the guarantee and the carriage not being sufficiently close.
Yes, because Lord Phillips at 1335 told counsel for the second defendants that he didn't wish to be addressed on common law remoteness, but was then addressed on remoteness in the context of the convention itself.
Yeah.
Yes. The criticism of the remoteness, the importation of remoteness, is muted. Paragraph 42 on 1348. The court sympathised with the perceived need to restrict the scope of Buchanan, but thought it unfortunate if the decision imports the application of English principles of remoteness. And indeed, that's another criticism of Buchanan, which is advanced.
Mm.
I think you were going to give us 4 criticisms of Buchanan.
Yes,
you were distracted.
I think I got stuck on one.
Yeah.
The first relates.
It wouldn't do your argument any harm, would it, if we were to leave the decision in Sandeman standing, but explain that that there may be alternative ways of reaching that conclusion which might be preferable?
Lord, it wouldn't, no. And indeed, perhaps the greater menace is the first one I pointed out at the end of paragraph 38.
Yeah.
The suggestion that Buchanan should be confined to its own facts.
Yeah.
You say Sandeman should be confined.
Yes, indeed. They don't both. So the first criticism, as we understand it, relates to double insurance. And that was a topic I was going to address separately, but perhaps I can deal with it now. And our submission in relation to that is, first of all, double insurance is a fact of life. It's a fact of life in all forms of carriage, by sea, by road, I'm sure by air. I don't have any particular experience of that myself. But it's typical to have cargo interests and carriers who will at least have insurance cover up to the limit. Cargo interests will be covered for the full value of the cargo. Carriers must have liability insurance at least up to the limit. So to an extent, double insurance, if it's a menace, it is a menace which is an inevitable fact of life. But there seems no particular objection to that because it's been the status quo for a very long time. In the particular context of the CMR, it isn't only Article 23.4 in this jurisdiction as a result of Buchanan that potentially puts on a carrier a liability in excess of the limit. There are many other reasons why a carrier might be liable beyond the limit. One reason is that other jurisdictions have followed Buchanan or come to the broad interpretation in their own way and would allow the recovery of excise duty under Article 23.4. So a carrier undertaking international CMR carriage is vulnerable to having to be made liable for excise duty in a normal case, even without willful misconduct, unless perhaps he's very careful to make sure his route takes him only through jurisdictions have adopted the narrow view, if that's possible, because one of the things you may have seen from the discussion about other jurisdictions is, for the most part, we don't know. We have information about 16, I think, of the 58 CMR jurisdictions. And we are agreed on about 8 of them in relation to what approach they've taken. For some of them, we disagree. But for the vast majority, we just don't know. And perhaps they've come to a decision and we don't know about it. Perhaps it's an issue that's never arisen. So any carrier engaged in CMR carriage would have to be alive to the possibility that he would be rendered liable for excise duty under Article 23(4) in another jurisdiction, even if not this one. And there's another reason why a carrier is potentially liable beyond the limit, and that's willful misconduct. Yeah. As soon as willful misconduct is shown, then the exclusion of damages in 23(4) is set aside, and that opens up the possibility for national law claims. So in this jurisdiction, one could then have claims for breach of contracts, for loss of profits, or any loss that would be proven. And the same would be true subject to whatever national rules applied in every other jurisdiction. So a carrier cannot guarantee that willful misconduct will not be found against him, because he's responsible not only for himself, but for his subcontractors and his employees. So the idea that one can compartmentalise insurance is just not realistic. That is not how it works. And pursuant to the invitation of the court, that the parties agreed the joint statement, which perhaps this would be a convenient point at which to show the court, which is in a supplementary bundle at page 6. I beg the court's pardon, page 4. And the slight health warning is this, of course, represents the knowledge and experience of the parties to this case, which is very much orientated in this jurisdiction. So we cannot speak to experience outside this jurisdiction so much, but nevertheless it's informative. And in relation to insurance, the summary is at the top of page 5b. The recoverability of excise duty under Article 23(4) in some jurisdictions and not others, in addition to the value of the goods as defined in Article 23 to 23(3), is just one of the many variables which impact on insurers' potential exposure and risk analysis. So it is part of a much bigger picture. And then the insurance position is discussed in more detail at page 6. Paragraph 9. It is usual for cargo interest and carriers to obtain insurance. Cargo insurers and freight liability insurers who offer insurance in relation to high-value items such as alcohol and tobacco tend to be specialist. Paragraph 10, many general cargo and freight liability policies expressly exclude tobacco and alcohol or require declarations for which additional premia are payable. 11, when specialist insurers underwrite cargo or freight liability insurance, they rate the risk according to the nature and value of the cargo carried and the loss record of the insured. Specialist insurers usually rate risk on the basis of the full cargo value, which in the case of excise goods carried under an excise suspension regime will include excise duty. So that the insurance market on both sides is insuring full cargo value, including excise duty. 12, specialist cargo insurers are aware the duty can be applied if goods are released from an excise duty suspension regime. 13, duty would be recoverable under a cargo insurance policy. And then at the top of page 7, specialist carrier liability insurers Again, risks are routinely rated on the assumption that potential liability of the insured will be the full value of the products carried, including excise duty. And then 17, specialist carrier liability insurers are aware that it's easier to break the limits in Article 23 of the CMR in some countries than in others because of the different way in which the willful misconduct test under Article 29 is applied. So that's another area where there is disharmony. In this jurisdiction, the test for willful misconduct is quite strict, and it requires something akin to knowledge that what you're doing is wrong and may lead to loss, or at least conscious recklessness or careless recklessness. In some jurisdictions, for instance Germany, they have a concept of gross negligence, which is easier to substantiate. And specialist carrier liability insurers are aware that as a result, it's easier to break limits in some jurisdictions than others. They are also aware that in some jurisdictions, excise duty is recoverable in addition to the value of the cargo as defined in Articles 23, whereas in others it's not. They tend to assess risk and set premium for alcohol and tobacco products on the basis of liability beyond Article 23 because of these uncertainties. So the insurance market is sophisticated. They are alive to the fragmentation in different jurisdictions. And necessarily they have to accommodate that and provide cover and set premium on the basis that as a carrier you might be liable for excise duty under 23.4 in a jurisdiction where that is the approach that's taken, or under Article 29 for willful misconduct, and that is easier or more difficult depending on which jurisdiction you happen to find yourself sued in.
About the difference in approach to willful misconduct. Is that dealt with in any of the documentation before us? Or you're just telling us that?
My Lord, there is, in addition to the joint statement, there is an article. It's in the second supplementary bundle. I can give the court the reference. Yes, a second supplementary bundle, page 15, or maybe starting at page 14. And this is an extract from International Carriage of Goods by Road by Professor Clark. And at the bottom of 14, he is discussing equivalent default, because of course Article 29 refers to willful misconduct or equivalent default under national law. And then at 102A, he starts to talk about the different kinds of equivalent default. And at 102B on page 15, the second and broadest kind of equivalent default is shaped by rules of national law, those rules that reflect such a degree of social disapproval. The best example of such rules is that concerning Die große Fahrlässigkeit in the law of Austria and Germany. The concept corresponds roughly to what common lawyers understand by gross negligence.
Yes, thank you.
And there is a similar reference at page 36 in the equivalent text from Messenton Glass, paragraph 9.82, I think. So I think it's well accepted that there are variations between European jurisdictions as to how willful misconduct is dealt with. So we say the first criticism is not convincing. There is no undermining of any objective of the CMR in relation to double insurance. And indeed, double insurance is not something which one can avoid, certainly not through the actions of one national court. It would take a revision of the convention as a whole, including Article 29. One would have to look at that again, if that was really an objective. That's the first Sandeman criticism. The second is at page 1345, letter H. And that is the Article 26 point, and it suggested that Article 26 is designed to enable a consignor to impose liability on the carrier for a value exceeding the Article 23 limit and for possible consequential loss. And that is put forward as being the more natural way in which to protect against excise duty. We have addressed that in some detail in our written case, and there are a host of practical reasons why Article 26 is not an appropriate mechanism by which a cargo interest can protect against the imposition of excise duty. That's at page 161 of the bundle. And just to address those very quickly, first of all, as far as the respondent is aware at least, Article 26 is not something that's used in practice to any degree, and that experience is reflected in what they say in the joint statement at paragraph 21b of that document. And there's also a reference in the views of Professor Clark in paragraph 100 at the second supplementary bundle, page 11.
And the scheme of convention assumes that it can and will be.
Indeed, but in practice, if one is thinking about the practical, if one takes the view there are practical problems caused by Buchanan, and is searching for a better way of approaching it, then in our submission, Article 26 is not that better way. Because whatever may have been the intention behind it, and one can debate whether excise duty was in the minds of anyone when Article 26 was conceived, in practice it is not used. That's the first point.
Can I just mention to you, you've only got 5 minutes left, so you have to bear that in mind.
I have, thank you. Thank you, my Lord. The second problem is that in order to accept an Article 26 declaration, a carrier needs first to agree with his insurer that he can accept it. So it's not as straightforward simply as agreeing that you'll accept the 26 declaration. There will need to be a process of notifying the insurer and agreeing that he is happy for you to do that. The third point is, as we've seen from the joint statement, in practice, both cargo interests and carrier liability insurers cover exposure up to the full value of the goods, including excise duty. So there's actually little point, given the way in which insurance arrangements currently exist, that there's no point, there's no incentive to use Article 26. And that is a product of the fact that both cargo and carriers need to have insurance for the full exposure of cargo value and excise duty for the reasons I've set out. Another point is, and as I showed you by reference to the directive, it is possible that it might be the consignee who is the one who's exposed to excise duty, if he's the one that gives the guarantee under the duty suspension arrangements. But Article 26 only allows the sender to make the declaration. There is no mechanism to protect a consignee in similar circumstances. So for those reasons, we say Article 26 is not a viable solution. The third Sandeman criticism is at page 1347 of the judgment, B to C, and the Court of Appeal said that the Buchanan decision is not one which lies happily with the approach to the ambit of Article 23.4 of the courts of most of the other signatories to the Convention, France being an exception. And quite why that comment was made is not clear, because it doesn't appear there was any argument before the court about the position in different jurisdictions. And indeed, based upon what we know through the researches of the appellants, it seems unlikely that could have been the position, because now there is fragmentation, and indeed, at the time of Buchanan, as the court observed, there was equally fragmentation then.
I see in the following paragraph 39, the Court of Appeal make the points that I was putting to you a few minutes ago. I won't take up your time with that, but I see they're there.
Well, I would need to know a little bit more about the circumstances in which a guarantee is required, so one doesn't accidentally end up making a different regime for smaller enterprises who have to give a guarantee, rather than larger enterprises which may not have to give a guarantee. I mean, I don't know when a guarantee is required. If it's always required or only sometimes, and what the criteria are.
As I say, it's probably the invitation in paragraph 38 to other courts not to extend Buchanan beyond its facts, which is more concerning, rather than the grounds of distinction. I mean, I accept that there may be grounds of distinction which are valid. I'm conscious, my lord, that my time is up.
Yes. Very well. We're very grateful, Ms. Buckingham.
Thank you.
Yes, Mr. Kilmer.
I have 15 minutes, so I took up
Yes.
most of my time. Can I start first of all with the Buchanan-Sandeman point? We submit there's no distinction between Sandeman and Buchanan. In both cases, there was a liability assessed by the excise authorities. In the case of Buchanan, it was assessed directly because the whiskey was lost. In the case of Sandeman, it was assessed via the calling in of the guarantee. Mr. Buckingham very fairly took you to the directive, which clearly foresees and said it's not a different liability, in answer to a question from Lady Rose. He said it's not a different liability, they're just mechanisms, and that must be, in our submission, right. So in both cases, you have a liability arising due to miscarriage of goods. Although the seals may have no intrinsic value, they were undoubtedly goods, physical goods received for carriage, and they were lost. Same as the whiskey in Buchanan. So the problem that Sandeman reveals is that if you apply Buchanan literally, and the ratio literally, you end up with an extremely wide recovery, which would apply in virtually any tax imposed as the result of the loss of physical goods. We've concentrated on excise duty, but it could be luxury, it could be consumption tax, it could be a fine, a penalty, it could be any liability. Under the ratio of Buchanan, if if it's right, we say it's wrong, but if it's right, any liability rising from miscarriage of goods is recoverable as a charge under Article 23.4. We say neither of the liabilities, so neither the guarantee liability in Buchanan nor the direct assessment, the guarantee in Sandeman nor the direct assessment in Buchanan were charges in the relevant sense, because there might in some way be charges on goods, but they're not charges under Article 23.4, because what's required is it's in charge in relation to the carriage of goods. So that is the problem, that there isn't really a distinction between the two. And although the Court of Appeal said that it wasn't a charge, it didn't explain why applying the Buchanan decision it couldn't be. And my own friend is wrong in my submission to say that foreseeability, also the Article 23.4 wasn't really at the centre of the debate in Sanderman. It clearly was, and that's why the Court of Appeal said the crucial issue in this case is the scope of Article 23.4, and they expressed their view on it. That the key part of the problem, the second key problem with Sanderman that it reveals is this issue of foreseeability. And in relation to that, you've got what I say on pages 26 and 27 of my note, namely that the poor trial judge in Sanderman accepted the views that were expressed in the major commentators, that Buchanan couldn't be literally read as it appears on the page, as giving rise, as leading to liability simply because there was a financial liability caused by a miscarriage. Something has to be read in. And the two commentators said it's got to be some sort of remoteness. And that was the key issue in Sanderman. The trial judge said he found that it wasn't too remote for the contractual carrier, but it was too remote for the two successive carriers. And that's set out in footnote 2 on my page 27. When it gets to the Court of Appeal say, well, we can't possibly use remoteness. Remoteness should have no place in the construction of the convention, and that's, we say, is absolutely right. It's a telltale sign of a real problem with Buchanan, that you need to have some sort of remoteness test. Now, whether it's domestic law remoteness or some other form of remoteness, we say neither is required, because the way it was envisaged to work was very simple. Compensation was the market value at the place of dispatch, plus the refund of charges related to carriage that you were paid. It's a refund provision. And if you're not satisfied that extra duty is a refund of a transport or carriage charge, then that's at the end of the appeal, and you should find in our favour. I want to come to the retrospectivity point and deal with that. Yes, we fully accept that in any case where there is a construction of a commercial convention, there's a risk of undoing settlements. But the practical risk, we say, is minimal in this case for two reasons. First of all, because of the way that this court has decided to interpret the limitation provision in the FII case, which is, the references are for that, the supplementary bundle 1, 252 to 253. So the question is, has there been a reasonable, with reasonable diligence and reasonable expectation, has the limitation period already begun to run? We say at the very latest, realistically, that had begun to run in this case, is when the Sanderman decision came out. Could have been even earlier. There's been a cause of disapproval right from the beginning, but that was in 2003. So the standard 6-year limitation period has long gone. That's point number one. Point number two, it's difficult to conceive any unjust enrichment claim succeeding, because there'll be a change of position defence. These are all commercial transactions. The idea that someone will have pocketed the excise duty, put it in an account, not spent it, not touched it, not changed its position in reliance on it being secure, is,
well,
we say.
Well, you say that. I think in FII, actually, it was held that the revenue couldn't run a change of position defence.
They couldn't, but I think that's I recall that is a special that's a special problem for the revenue.
Yes, but it'd be relevant in...
Yes, but for commercial parties, it would be a... so as long as you're... So, yes, of course, it is a factor. We fully accept that a change of a interpretation in relation to a treaty to do with commercial transactions does have that. But it's only one factor to be balanced with others. And if you're satisfied that, as I say, you ought to be, that Buchanan has really gone very seriously wrong and undermined the proper risk allocation of risk under the treaty and led to injustice, then you shouldn't be put off by the potential for undoing a very small class of transactions, which would have to be up and running now in some way and not time barred. As to the said against us that we don't have a change of circumstances, we can't identify any. We do. The change of circumstances since Buchanan are four chief ones. First of all, Sanderman and the uncertainty that leads to. Secondly, the chorus of disapproval and the total lack of support for it. Thirdly, the decisions of the Swedish court, the Netherlands court, and the German Supreme Court. And fourthly, the emergence of a settled view under SIM. In relation to SIM, I don't, of course, suggest there weren't decisions going the other way, but certainly I'd ask you to look carefully at where the COTIF had reached in relation to its views and the views by the time, just before the decision to pass the Vilnius Protocol, and certainly by the time you had the decision of the German Supreme Court in 2004. So it's the bundle page is 2708. By the time of that decision, we say, so at the latest 2004, a settled view had emerged. So we don't deny there had been previous decisions, including the French one that is what causes the COTIF to put the bulletin out. It says the French have decided that excise duty should be claimed. We think this is wrong. And if you read the OTIF document in the bundle SP1 497, and carefully, you can see that we say that COTIF is saying very clearly excise duties have never intended to be recovered under SIM. Never, ever. And I accept that there were some drafting queries, and as always, different people had different ideas about how to change the SIM, but the underlying intention was clear, which was to put it beyond any doubt that excise duties should not be recovered. So that's what they were trying to do, and that means that if you uphold Buchanan, you'll have two bits of English law which contradict each other, because SIM is just as part of English law as a CMR. And you haven't heard anything from my own friend to suggest that you should interpret SIM differently. And there may have been some, as I say, some drafting disagreements. But as things stand today, we say you have to interpret them in harmony. And
you're talking about the interpretation of SIM before the variation expressly to exclude excise duties.
Well, we say they're the same.
I know you say it was the same all the way through.
Yeah, but now...
We can only be construing SIM now with that express exclusion written out.
So if you're asking yourself, is there...
the difference in law would arise from the fact that now very differently worded.
Yes. I mean, if I'm wrong that it hasn't, that you say, well, there was some doubt before, the position today is very clear that excise duties cannot be recovered under SIM. And I always intended to have to lead to the same result. So we say interests of harmony are an important change of circumstance since Buchanan was handed down. And although my friend says that we haven't been able to identify any difficulties in practice, we do say that I took you to the Shelling article about the undesirability and inefficiency of having these large potential claims outside of the cap, which inevitably increases insurance premiums. even if in practice I fully accept that some big carriers in particular will want to insure themselves against anything, so it may not make any difference to them. If they operate in a whole load of jurisdictions, they want to cover themselves for willful misconduct. But our point is that on the construction of this convention, the carriers shouldn't have to make allowance for huge potential liabilities under 23.4 for excise duties. As I said, 27 times the cap. That cannot, on any view, have been something that was contemplated or intended under the CMR. And my own friend said this morning that there weren't any real-life problems. I just remind, and only he suggested only perhaps academic problems. I would just remind you of the comments of His Honour Judge Pelling and the problems of my client facing such an enormous potential liability of 27 times the limit, but also, had he lost the entire load, is something that he wasn't even insured for because he insured himself up to $1 million. The limits under the protocol, I do say that is unfortunately genuinely a red herring. There was no, my own friend is right, of course, that he says Article 23 was under the microscope, but it was under the microscope for one purpose only, which was to deal with the fact that we'd come off the gold standard in 1971 and there was a problem under the CMR and under a whole load of treaties, and they all switched to STRs. That's all that it had to do with. It had nothing whatsoever to do with anything else. As to the issue of interpretation and whether you should be more cautious, again, I fully accept that as a general principle. You have done it, though, 3 times. You have reversed statutory interpretations, Oldendorf, Vesti in the IRC, and FII. And the key reason why, or one of the main reasons why it's not something that happens a lot is, as was suggested, that so often matters of interpretation are a matter of impression. But we say this is not one of those cases. If you apply if you apply the Vienna Convention under Article 31, you get to, we say, a clear result. It's not one of those ones which could go either way. And the final point, in relation to travaux, you don't need to be concerned about defining travaux for these purposes. We say all we need to do is apply Vienna Convention Article 32. That is much wider. It entitles you to look at preparatory work in the circumstances of the conclusion of the CMR. And that must include, we say, the provisions that we've identified and the documents that we've identified that were part and parcel of the drafting, albeit delegated in this particular case to a committee rather than a plenary session. And we say, therefore, those documents on page 93 qualify as under Article 32 of the Vienna Convention. That's all we need to show. Those are my reply submissions.
Thank you very much, Mr. Kimball. Well, we're most grateful to Council for their assistance and to those sitting behind Council who no doubt have also contributed. We'll now take time to consider the submissions and we'll let you have our judgment in due course.